Yes, Mr.
Thank you, Nugee. So I now move on to deal with monetary consideration, which only arises if you're with my learned friend on, not with my learned friend on non-monetary consideration. So it's now said before this court that the payment by the underwriter to Ingenie of the premium or part of the premium, the commission or part of the commission, the device amount, is consideration for the supply of the device service by Ingenie to the policyholder. So that's what we're having to consider here. But in our submission, you need to look at this two ways. First, in relation to the contractual obligations. And we say when you look at the CAVIA agreement, it's clear that the commission, including the £150, which we're labelling the device amount, was consideration for supply of services by Ingenie to the underwriter. So between Ingenie and the underwriter, you have a bilateral contract. You have the promise to get the device installed in the policyholder's car by Ingenie, and you have the promise to make payment of premium in return for that and other services that are provided by Ingenie to the underwriter under the CAVIA agreement. And that, in our submission, is undeniably a direct link with mutual exchange and reciprocal performance between the payment of the commission, the device amount included in it, from the underwriter to Ingenie, and in return the supply by Ingenie to the underwriter. And I doubt we need to go back to the CAVIA contract, but of course it's clause 4.4.1, which puts the obligation to install the device on Ingenie owed to the underwriter, and one can see that that's in return for payment. Remembering clause 4.5 doesn't exclude the commission being payment for that, and we see the commission clauses at clause 9.1, including clause 9.1.1, so £150 per product, that's per insurance policy, if no device is already fitted to the policyholder's car. The question is, does that analysis then seem consistent with economic reality? And in our submission, there's nothing in the arrangement between the underwriter and Ingenie or the wider arrangements that suggest that that could possibly not be a realistic analysis. And so if that is a realistic analysis, in our submission it follows that the role of the commission payment in these transactions is clearly identified. It is consideration for a supply of a service by Ingenie to the underwriter, and there's no room for it to amount to anything else. For it to amount to anything else, there would be double counting.
Why can't it be both? Let me take a rather simpler analogy. A father contracts with a painting and decorating company for them to paint his daughter's house. We know that's a perfectly good contract in English law. We know that the father pays the money. He's paying the money for two things. One, because he's getting a contractual service of having his daughter's house painted, but it's also a service to the daughter who gets her house painted. Why can't the £150 be consideration for both both the supply to the father and the daughter, or in this case, both the supplier to the underwriter?
Well, in my submission on that example, the VAT supply is to the daughter, and there would be third-party consideration coming from the father. And that's not a problem in the VAT analysis because third-party consideration is possible and perfectly good for VAT purposes. But any benefit to the father, if there is any, is too indirect in our submission. And here, it's clear that there is a benefit going to the underwriter.
But there is also a benefit going to the policyholder, because it's by having the box fitted that he can access the cheaper insurance.
Well, in our submission, that simply can't be seen separately from the insurance. In terms of the relationship with the insurer, the insured wants is a policy of insurance. Now, he may need to take, in fact, will need to take the device in order to receive the policy of insurance. But in our submission, it's wrong to categorise the device in that way as a benefit to him when you look at the overall arrangements. It's just something he has to have in order to benefit from the insurance product he wants, and if his driving gets better, to get a lower premium. It's not an aim in itself, and it's not to be sort of split out as a separate benefit in our submission.
But just come back to my Lord's example. Did I understand you to say that that would not involve any supply to the father, even though the service is being provided pursuant to a contractual obligation entered into with the father?
Yes, my lord, because there can be a contract between the provider of third-party consideration and for VAT terms, and the supplier of the services, and the supply of the service can be to somebody else.
Well, if that's right, why in our situation is there a supply of the device service to the insurers merely because ISL has contracted with the insurer to provide it to the policyholder?
Because of the benefit to the insurer, because the insurer needs the device fitted in order to operate the insurance policy, in order to have data collected and sent to him in order to review the premiums, or if there's a serious instance of bad driving, to terminate the policy.
Why is that different from the benefit to the father in the delight that his daughter has over having her house painted and the filial affection that reinforces?
Well, in our submission, if you're looking at VAT in an economically and commercially realistic way, one's not taking into account pleasures, subjective pleasures that a parent gets from a service that is provided to and enjoyed by their daughter.
So it's the economic advantage.
Yes. And can I just take you to, I think it's easiest to take you and my learned friend's skeleton to a quote from 47 Park Street. It's core bundle, page 48. No, sorry, I beg your pardon. 52.
So sorry, where are we going?
Core bundle 52, paragraph 71. Core bundle, page 52. Divider. It's my learned friend's skeleton argument. So I think you may have that separately. I'm not sure, my lord.
I do.
If not, it's tab 4.
I'm there now, thank you.
Could I just invite you to read that? So Lord Reed gives it as an example there, but the situation in which he's envisaging a payment by a business may be third-party consideration is when the cost of the supply can't realistically be regarded as
of which it cannot realistically be regarded
yes,
as the recipient.
as the recipient. So the question is, can or a question as a matter of commercial and economic reality, is can the underwriter realistically be regarded as the recipient? And in our submission, it can be.
It comes back to my question, can you not have two recipients? Can it not be service supplied both to the underwriter and to the policyholder? Because they both benefit from, or at least think they're going to benefit from having the box.
Well, our submission is that the policyholder doesn't benefit from having the box separately from the contract of insurance, and that's very important here. It's of no benefit to him apart from the contract of insurance. It's of no benefit to him during the contract of insurance, except for the role it plays in his being able to obtain the insurance in the first place, and the possibility of better driving affecting the premiums.
So you say in economic terms it's not a benefit to the policyholder. Is that how you put it?
My lord, yes. But
why is there then a supply? You can have a supply of services of no economic benefit, can you? Because you concede there's a supply to the policyholder. You're not challenging that in this court.
I'm not, my lord, but here one, I think, can make the distinction that I'm seeking to make, that when one's looking in terms of the overall relationships and the arrangements between the underwriter and Ingenie, that there's no benefit to the insured outside the benefit of having the insurance. And that's, I think my first point is that there is a clear benefit here to the underwriter. And that if one looks at the contractual terms, one can see that a price has been stipulated. There are mutual promises as between the underwriter and Ingenie. So that gets us back to the situation where the contract is saying a price has been stipulated and agreed, an exchange has been agreed, a performance payment of the commission, of the commission, in exchange for the rendering of all of the insurance intermediary services that are rendered by Ingenie to the underwriter. As part of that, there's £150 which is clearly related to the installation of the device. And that's what has been agreed between Ingenie and the underwriter, will be provided to Ingenie as in return for providing the service to the underwriter.
Well, I understand the argument that if you ask the question, what is the underwriter paying the device amount to ISL for? The answer is in return for the fulfilment by ISL of ISL's promise to the underwriter that it will fit the device. And therefore, I understand the argument you say, that's what that's for. And it's not for anything that ISL may or may not have undertaken to do vis-a-vis the policyholder. That would still be what it was for, whether or not ISL had, in part one, made a separate promise to do so. That aspect I understand. What I don't quite understand is the suggestion that providing the service to the policyholder doesn't confer any benefit on the policyholder.
Well, can I move away from that for a second and say that in our submission, where you have that contractual relationship and all is clearly identified in the contractual terms, and then you have a situation in which in our submission it's indisputable on the facts that a benefit is being conferred by that service, a direct benefit on the contracting party, in this case the underwriter who's making the payment, that you don't need to look further than that. You don't need to consider whether there is also some benefit to another person through the carrying out of the device service.
Well, I would have thought that the way you would seek to answer my Lord's question is it can't be consideration for the agreement to supply and supply to the policyholder, because it's a matter of entire indifference so far as the insurer is concerned, whether or not that is an undertaking, contractual or otherwise, which has been given directly by ISL to the policyholder. It's an undertaking that's been given to the insurer, and that's what the insurer promises to reward the fulfilment of by ISL, full stop. It's not paid for any obligation to supply or supply to the policyholder as such. It's paid for the obligation owed to the insurer.
Well, that's, I think, definitely my first point. Maybe I've muddied the waters a little, and I see your Lordship's concern that if there is no benefit at all to the policyholder from the installation of the device, it's difficult to say that there is a supply to it, which is something that we have.
Well, I also have difficulty with the idea that there isn't some benefit to the policyholder. Myself, as I think possibly my Lord does.
Yes.
Yes. So I think there are two problems facing.
That's why I'm just seeing whether your argument stands or falls on your submission that there's no benefit to the policyholder in having the device installed.
The answer to that is no. I also do have some concerns that I've thrown myself back too far into an argument that we were making before the Upper Tribunal and not pursuing in relation to there being no supply. And before you, we accept, as the tribunals held, that there was a supply. So I think my economic description of there being no benefit outside the taking of the insurance policy is correct, but it doesn't mean that there's no benefit to the policyholder from the device service. And I think I muddied the waters.
Is your position as simple as this? The policyholder may get a benefit from having the box installed, But that's all something the policyholder gets by paying the premium. Has paid the premium and gets a policy which comes with a box. They're not paying anything separate for the box because it's agreed they don't have to pay anything separate for the box. The underwriter does pay something for the box, pays £150. But that is explicable entirely on the basis that that's what the underwriter wants and gets, which is a policy holder who has a box in their car, so that the underwriter can administer the policy accordingly. So you don't need to attribute any of the £150 the underwriter has paid to any benefits there may or may not be to the policyholder.
That's right, my lord. I think that puts it crisply and more crisply than I had. That's why one focuses on the contractual terms.
Yes.
That's what the contractual terms tell you, and it's why I think we can deduce that Ingenie runs its case in the way it does. Its primary argument being that there's some non-monetary consideration. Its alternative argument being that there's monetary consideration.
And as I understand it, there's no conceptual impossibility about a supply being made to more than one recipient. Is that right? And if that is so, then in an appropriate case, one might have to do some kind of apportionment of the consideration or to reflect the respective benefits which they're obtaining. Or is that not the kind of question one should really be asking in this context?
I think that's moving very far away from the contractual terms and the facts of this case. And I suspect my client would rather I concentrated my submissions more closely on the facts of this case.
I don't want to take you down a byway which is irrelevant. I was just slightly taken aback when you said that once you found a direct benefit to the insurer, there's no need to look further, which it may, on a perhaps rather literal interpretation, sound rather contrary to the exhortation one is constantly encountering to look at the facts as a whole, which also means not stopping once you've reached a particular point, but going on to make a fair and objective review of the totality of the arrangements.
Yes, but I think on the totality of the arrangements, my Lord Justice Nugee made the point that the policyholder is being told in the policy booklet as a whole he's not being charged and he's not he's having to pay pound nothing for the box. But if I can leave it there unless your lordship wants me to follow up on that.
No, not at all. We've got a lot of ground to cover, so I'm not going to detain you. Thank you.
So that's dealt head on with why we say there's no third-party consideration. Given that only third-party consideration is urged upon you in this court, I'm not sure it's needful to say much more, other than to say, with respect, my lord, we certainly perceived and agree that an argument on consideration that wasn't third-party consideration, but was money consideration, was run in front of the Upper Tribunal. Why we say that is, to some extent you can see from the diagram in my learned friend's skeleton, it's not just a question of looking at the commission and the payment of the commission to sorry, it's not just looking at the payment of the commission by the underwriter to Ingenie. It goes back into looking where the origins of that payment are, and the diagram tries to show coming through an amount of the premium being paid in respect of the device, which is never identified to the policyholder who's told he's being charged nothing extra in relation to the device. And then the submission was made to the tribunal that the amount of the £150 for the device amount, indeed all of the commission, were amounts that the underwriter could not take for themselves in VAT terms, seeking to argue by analogy the Glaverspiel case, which is referred to in the skeletons. And if the Upper Tribunal was being told that in VAT terms, this amount of commission was money that could not be taken by the insurer for itself, it seems hard to fathom how that is actually third-party consideration. But I don't think that advances the argument that's now made before you. It just simply seeks to explain why the Upper Tribunal thought it was doing what it was doing. Can I move on to the need for consideration to be capable of being valued in money terms? Our main argument on this part of the case is that the consideration is not capable of being valued in money terms because the parties to the arrangements viewed as a whole had agreed that no charge was going to be made to the policyholder for the device services. That was a subjective agreement valuing the device. And if you have a subjective agreement, sorry, the device service, and you have a subjective agreement of the value of the device service that is nil, then it's clear that there's no monetary value can be attributed to the consideration.
But does it follow that because the parties agree that something will be provided free, they don't attach any value to it? I mean, what about free gifts? What about Empire Store's gifts?
Well, those weren't free gifts. They were.
Well, they were ones that,
Yes.
that the customer didn't have to pay for. So in just the same way you're saying the policyholders agreed he doesn't have to, he won't be charged for them. The parties in that case agreed that they weren't going to be, that the customers weren't going to be charged for them.
In our submission, that they were gifts in return for monetary consideration, or some monetary consideration, some non-monetary consideration. I mean, if I could just run through, we accept that capable, if I could put it that way for shorthand, is a requirement. And one sees that from naturally yours and Empire Stores. But the allied requirement is of subjective value, and there's no dispute between the parties. And the Upper Tribunal agreed that the value must be subjective, not objective. But then there's the need to identify the consideration and then value it. So the consideration here is either the policyholder agreeing to enter into an insurance contract or the policyholder agreeing to the installation of the device, or both. And the Upper Tribunal then just looked at that in fairly general or abstract terms. It might help to have the decision of the tribunal in front of us. It's core bundle, page 100, 76 to 79, paragraph 76 to 79.
Sorry, which tribunal are we looking at first here?
Upper Tribunal,
Upper Tribunal.
page 100 in the core bundle, paragraphs 76 to 79. If I can invite you to read that.
Sorry, I'm looking at the wrong. Thank you.
we say the tribunal erred and held it was sufficient that the value of the services is capable of being expressed without taking into account properly that the subjective value might be nil, particularly the subjective value might be nil, because that is what the relevant persons had agreed. And it was easier for the Upper Tribunal to miss that, as we say it proceeded in a wrong order, really. It should have decided if there was reciprocal performance and the necessary direct link, so whether there was consideration for the supply, and then gone on to see if value could be attached to it. And that caused it to overlook the fact that it shouldn't have been looking for a benchmark value, because it had been agreed that the value of the device service was nil. And we say we see that agreement in the positively in the second part of the policy booklet, where we see no extra charge and we see reference to nil.
Well, what we see is that it was agreed that the cost to the policyholder would be nil. Non constat that the value to the policyholder is nil, even less so that the value to ISL of getting the contract entered into was nil.
Yes,
That's not, they haven't agreed that, have they?
well, in my submission, the first thing one should be looking at is whether there is an agreement between the parties to the transactions here, that as between the parties, what is the value of the device service going to be? And what's agreed is that there's no value going to be attached to it. That is what I say has been agreed in the policy booklet. Also, in the TOBA, one sees reference to the £45. I'm going to call it, might be slightly misdescribing it, missed appointment charge, but there's no value being put on the first installation of the device in the TOBA. And we also have clause 4.5 of the CAVIA agreement, where it said that there's going to be no remuneration other than the premium for Ingenie. And we say in those circumstances, one can, looking across the agreements, see that there's been an agreement that the value of the device service is nil. That's certainly something that the policyholder has been told, and there's no need in our submission to look behind that. Now, I agree with your lordship that that doesn't mean there isn't any cost to the Ingenie of getting the device installed.
Well, I was making a separate and earlier point. It doesn't mean there isn't any value to the policyholder. The fact that it isn't, that the agreement is simply the policyholder will pay this much in premium for everything, including the installation of the device, and that there isn't, it's agreed there won't be a separate charge in addition to what's being paid by way of premium for the installation, doesn't mean that no value is being put on the installation of the device by the policyholder. It simply means that that value is all included in what he has to pay by way of premium.
Well, a value is being put on the supply of the insurance by the underwriter to the policyholder.
Correct. That's the whole premium.
That's the premium.
That's the lump sum, and that includes, from the policyholder's point of view, the service of having the device fitted.
That includes, from the policy point of view, the service of having the device fitted pursuant to the obligation which is on
Which the policyholder knows nothing about. For the policyholder's point of view, he pays the premium and he gets the insurance, and the insurance includes getting this device fitted in their car. And the fact that the policy says you're only going to have to pay the premium, you're not going to have to pay anything separate and extra for the device to be fitted. That's all part of what you get for the premium. Doesn't mean that there's no value being put on the installation of the device, which is part and parcel of everything which the policyholder has to pay the premium to get, does it?
Well, we're looking here at the value of consideration for the service of fitting the device supplied by Ingenie to the policyholder. And we're looking there to see a subjective value for that. And in our submission, you can see in the context of the arrangements as a whole that the subjective value that's being placed on it is nil. That doesn't mean objectively there isn't a value to the policyholder. And it doesn't mean objectively...
Sorry, it's my fault. I just don't understand why you're saying the subjective value from the policyholder's point of view. What he gets in return for the device being fitted is the insurance. Yes, it's not the only thing that the insurance is for, but the insurance and the premium and the fitting of the device are all an indivisible part of one thing so far as the policyholder is concerned, aren't they? He gets his insurance, the insurance has to have the fitting of the device, and he has to pay the premium for it.
Yes, he has to pay the premium, but overall in the arrangements, most clearly between the underwriter and the policyholder, but nice which you can't divorce in the overall scheme of the arrangements Ingenie from this. It's been agreed for the purposes of this transaction that the value that's being agreed to for the supply of the device is nothing. So that's the subjective agreement. And where you have an agreement that the parties have actually placed, written down in the policy booklet, that there's going to be no charge, £0 for the provision of the device. There's just going to be a charge for the provision of the insurance by the insurer. Then that deals with the value that's being put on the separate supply by Ingenie of the device installing services to the policyholder.
Well, we've explored the policyholder's position. If we look at ISL's position, what we're trying to value in monetary terms is the consideration which ISL gets, which is if we're at this point, the policyholder entering into the insurance. That's what we're valuing.
Yes. And
why do you say that ISL has agreed that that is worth nothing to it, ICL?
Well, because that's the value that's been put on it in the policy booklet. No different value has been put on it in the TOBA. It's all proceeding on the basis.
No, so sorry, what's the it? We're not talking about
the supply of the device service.
No, because what we're trying to value here is the consideration, isn't it? The non-monetary consideration. And the hypothesis that we're at this stage of the argument is that we're trying to value the value to ISL of the policyholder entering into the contract of insurance.
Yes.
To take them. So we're not trying to value the provision of the device services. We're trying to value what ISL gets in return for them, aren't we?
No respect, I think we're trying to value the provision of the device service.
But that's not the consideration.
Well, no. But that's the service which we're trying to work out what the consideration is for. And the consideration here is non-monetary consideration. So you may need an Empire Stores method to value it, but you don't need an Empire
Forgive me for interrupting.
Yes.
If just conceptually, if the agreement is, I will do A in return for you doing B, and B is the consideration that has to be capable, B is non-monetary and has to be capable of being expressed in a monetary value, then if the parties have agreed what B is worth, then we can see what that is so. But why is that infected by any agreement, if there is one, as to what A is worth? I just don't see the logic in that, I'm afraid. That's not what we're valuing, is it?
Well, in my submission, it is ultimately what we're trying to value, because we're trying to work out what the consideration for that is. But the parties have applied a subjective value to the consideration by saying that the service is for £0, and that's that's the long and short of my argument. And I'm not sure that I can develop it any further. If your lordship thinks one's got to go beyond that, and the party's just saying that is not sufficient, and then one needs to look at the consideration aside from any value that parties have ascribed to the supply itself.
But does it involve having to say that if I supply a service to you, in return for which you supply a service to me, the value of the two services must be identical? Because that seems to be the logic of the argument. If you say you value one by reference to the value of the other, which would be contrary to, I would have thought, the real world economics of most transactions.
Well, it's whether the parties have applied a subjective value to the transaction. In my submission, by agreeing that the value of the device service is nothing, the parties have achieved that. But I don't think I can develop that argument any further. If you don't think that there's an agreed subjective value, partly because there's no agreed subjective value for the consideration, that is for, should we take as the example, entering into the contract of insurance by the policyholder. I mean, we say one way of looking at that is that there's simply no detriment on the part of the policyholder at all. Entering into the contract is overall a benefit to him, or viewed objectively, perceived as a benefit to him. He doesn't give up anything valuable in terms of entering into a contract that he wants to enter into, or in allowing the device to be installed in his car. If one doesn't approach it from that angle, and one approaches it from the Empire Stores angle, we accept that if that's the route you have to go down, in this case, there can be a value expressed in monetary terms, and we've dealt with that in our skeleton argument at paragraph 64. So if we're wrong on the issue I'm addressing you on now, we accept that the value of the service or the provision and fitting of the device supplied by ISL to the policyholder is the cost to ISL of purchasing the device and of obtaining the fitting service.
Thank you.
Will you forgive me for a moment? So that brings me on to our final respondent's point, which is on exemption of the service provided by by Ingenie to the policyholder, and now you will be against me because you've found that it's a service for consideration, monetary or non-monetary. So it's a question of whether it's a taxable service or an exempt service. So can I take you first? I think we should, unless you tell me not to or ask me not to, we should look at both the European legislation and the UK legislation.
Yes.
So the European legislation is in the authorities bundle, unsurprisingly, tab 1, article 135. Sorry, I hesitated when I was getting my glasses. And it's 1351A. And that's been implemented in the UK in longer form. And that's on divider 3 in the authorities bundle in the Value Added Tax Act, page 94. And you'll see there Group 2 of Schedule 9 to the Act.
So which page are we on?
Page 94.
Thank you.
And you'll see item 1 is insurance and reassurance transactions. And no doubt through my mistake, the Upper Tribunal thought that we might be contending that this relevant service was an insurance transaction. Well, we shouldn't have done, and I wasn't intending to submit that. So the critical provision is item 4. Could I ask you to read item 4, please? And you'll note reference there to services of an insurance intermediary, and in B, in the course of acting in an intermediary capacity. And then if I could invite you to read note 1, which deals with whether services are services of an intermediary, insurance intermediary. and then note 2, which deals with acting in an intermediary capacity. And it's note 2 that it was key as far as the Upper Tribunal was concerned. And you'll notice that you're acting in an intermediary capacity wherever you're acting as an intermediary between a person who provides insurance and a person who is or may be seeking insurance or is an insured person. And it may help to at least have out, perhaps to look at what the Upper Tribunal said on this again. It's on page 92 of the core bundle. Paragraphs 44 to 50. Could I invite you to read that? Of course, you can skip out paragraph 45, perhaps unnecessarily. I took you that in the authorities bundle rather than in the decision. And the submissions in our skeleton on this, because those are the submissions that we wish to make, are in our skeleton argument, core bundle 74. You'll note really now, paragraphs 54 to 62. And as you've seen, the Upper Tribunal held that the device service was capable of being the service of an insurance intermediary within Note 1. And we say that's true of Note 1 and also of the PVD, Article 135(1). And when considering Note 1, it's one of those instances where the UK has definitely not just transposed the directive into national law, but has tried to spell things out in some more detail. This is to be given a conforming interpretation to the Article 135. And so it's not to be thought that one has to pigeonhole the supply of services into only one of the subparagraphs of Note 1. So something can be the carrying out of work preparatory to the conclusion of a contract, and also bringing together people as required under subparagraph A. And
why is it carrying out work preparatory to the conclusion of a contract if it's only in fact ever done 10 days after you've entered into a contract?
Well, indeed. So I think we identify the provisions that we say are most apt here as C, the provision of assistance in the performance of a contract, because the installation of the Ingenie device is obviously necessary.
Well, it's performance, I think you say, of the insurer's obligation under the policy.
Indeed.
To the policyholder.
Yes.
So it's the provision of assistance in the performance by the insurer of the insurance contract.
Yes. We say it's also a bringing together of the parties on these facts, because it's necessary for the device to be installed in order for the contract of insurance to be entered into. And we say that with some force if the analysis we're looking at here is a non-monetary consideration analysis, and the non-monetary consideration is the entering into the insurance contract by the policyholder, because we say that's very clearly a bringing together. This service is offered in this way. I think at this point the offer will be accepted by the policyholder entering into the insurance contract, so that there we have them brought together. That is them being the policyholder and the underwriter.
Would it be legitimate here to adopt a relatively broad brush approach by having compared, on the one hand, the very general wording of Article 135 with the much more prescriptive and detailed language in the 1994 Act, which you say has to be construed conformably with the, and that must, I think, obviously be correct, conformably with the directive, which is the primary position. If you do that, then standing back and looking at the picture as a whole, I mean, surely there's a great deal to be said for the proposition that Ingenie is indeed an insurance intermediary. Indeed, it's conceded it does provide a whole lot of insurance intermediary services we're not directly concerned with. I mean, against that background, the provision of the box is an absolutely integral part of the provision of this particular special kind of insurance that the individual punter wants to end up with. So, looking at it as a matter of common sense really more than anything, why on earth is that not a part of the provision of the intermediary services in the particular circumstances of this case? I mean, it seems slightly odd, in a very general term, for the revenue to be arguing in favour of an exemption from a tax, but that's probably oversimplistic as a reaction to anything in the world like VAT.
Yes, my clients do try, and it is their purpose to try and properly apply the law to the facts of the case. Of course, there's no guarantee they're fallible. They won't do so in every time. But if it is exempt, in their view, applying the law to facts, they should.
Well, I mean, if it's exempt, it's exempt. I mean, I guess wondering if maybe something peculiar about the way cash flows work or something like that that makes it positively advantageous to the revenue in financial terms to argue. But the point is, you're taking the point, and we have to determine it.
Yes, and on your lordship's point about broad brush, one shouldn't be deterred from obviously taking a purposive interpretation of Article 1351A and then not being caught up if a person is providing something that seems viewed in an economically realistic way, an insurance intermediary service within the purpose of Article 135, from either one worrying too much about which box it's in, or whether it can be more than one or another, or certainly not if you perceive it as clearly an insurance intermediary service within the Article 135, of falling between some gap that might have been left in the particular words of implementation here.
Well, for example, the reference to it being preparatory, I mean, one can see in a sort of conceptual sense, it is in a way preparatory to having an effective policy of insurance, even though it's only after, I mean, one that's going to operate in the way intended by all the parties, with a functioning black box, providing the necessary data to the insurer.
Well, I think particularly in this context, I submit that you can't look at it separately from the fact that this is something that's all coming together at the moment. The policy booklet.
And that seems to be just the kind of thing as a part of a conforming interpretation, or indeed a purposive interpretation, one should be able to take into account, rather than adopting a strictly literal approach and saying, oh, it's only going to happen 1 to 10 days after the policy is signed up to.
Well, the promise happens first.
The promise happens.
Yes.
The promise happens
Yes.
before inception of the policy.
And making a promise
It's a promise to do something after inception, as an encouragement. Indeed, as it's put in consideration for the contract being entered into.
Yes. So I mean, one shouldn't get into unnecessary temporal hang-ups, and one doesn't need to, given the wording of little a to d anyway. So the difficulty so far...
Sorry, just before... Did I understand your submission to be that Note 1 isn't in any event to be construed as exclusive, so that one can have services of an insurance intermediary, even if you can't squeeze them within any of the wording of Note 1?
I don't want to get carried away, because we must remember that Article 135(1) is to be strictly construed. That doesn't mean narrowly. That means in accordance with its purpose, looking at its words and its purpose and its context. But here we say we don't really have a problem. That was more of an overarching submission, but there's no real difficulty in fitting the device service rendered by Ingenie here into paragraphs. I set out how we say it can be done in my skeleton argument, and I stick to that.
No, I understand that. You say we're in A and all B and all C, but just as a matter of approach, we have to apply the English statute, don't we? And then if there's any incompatibility.
Well, part of the approach to applying the English statute is that it should be given a conforming construction.
Yes.
So it doesn't really arise. I'm not saying in this particular case you need to say that there's a particular problem with these words. They're not achieving the purpose of the directive, and therefore I need a very robust Marleasing conforming construction type of interpretation here. That's not necessary. So if I took us off into an unnecessary byroad, can I bring us back?
Thank you.
But the difficulty as far as the Upper Tribunal was concerned was whether we were acting in an intermediary capacity. And that's dealt with in the English statute, as we've seen by Note 2. And it's whenever the person is acting as an intermediary between a person who provides insurance and a person who's seeking insurance. And in our submission, when looking at the device service on the facts and in context, then it is the case that Ingenie is acting in an intermediary capacity. As a matter of economic reality, it can't be ignored that the case that at this point I'm having to face has succeeded in establishing that, what's happening in relation to the services are the services are being offered, the device service is being offered in order to get the potential policyholder into the policy. It's very direct and very clear. And that's certainly as between somebody in subparagraph A of little 2 and somebody in subparagraph B of little 2. So where is the problem, we say? And we say there isn't a problem. When we're looking at intermediary capacity, there isn't a particular specification of whether that intermediary duty is owed to one or other of the people in A or B. So we say that doesn't matter.
Mr. McCarthy suggested, I think, yesterday, that although ISL was the agent of the underwriter, it never acted as the agent of the policyholder. Have I understood it correctly? You say it doesn't matter.
That's the first submission, that it doesn't matter. Then on the facts, we have the TOBA, and you'll remember the introductory words.
So that's on your behalf.
Yes. It says that, and clearly we say that applies to Ingenie. Given the findings of the tribunal and what it says in the TOBA itself, one doesn't want to press too far the relationship of the TOBA to the fitting of devices. But nevertheless, there is some relationship because there's reference in there to the cancellation charge, or the, no, I don't think cancellation is the right word. Should we say the missed appointment type charge on the initial fitting of the device?
Just to be sure I've understood this correctly, the legislation, UK legislation, distinguishes between insurance brokers and insurance agents. Do we have any inkling of what the difference between them is, and which is ISL?
Well, I would say that's not of significance, because when we look at the words of the directive, it's talking about insurance intermediaries. So I don't think...
Well, actually, the directive also refers to insurance brokers and insurance agents.
Yes.
It doesn't use the word intermediary.
Yes, I beg your pardon.
I mean, my instinct as an insurance lawyer is that typically brokers are agents for the assured, and typically insurance agents are agents for the insurer. But whether that is a rigid distinction here, I don't know. But it doesn't matter for your argument, I think. Certainly on note 2.
No, I'm correct.
Because if the provision of the services was to the assured as agent for the insurer to fulfil that obligation, then that's as agent for the insurer. And if it was under an independent obligation, then they're acting on behalf of the insured for the purposes of bringing the parties together to create a contract of insurance. So it must be one or the other under note 2.
So yes, I think I was trying to answer my Lord Justice Nugee's question by saying both, but the answer is one or another. and which doesn't have any consequence for our argument.
Well, let's assume for this purpose ISL is an insurance agent because it's exclusively acting as agent of the insurer. The question is, does that mean it's not acting in an intermediary capacity? And that was, what is an intermediary? And I would have thought myself, untutored, it simply meant somebody who's between the two contracting parties.
Indeed.
And it doesn't matter whether they're agent for one or agent for the other or agent for both. Indeed, if they had to be agent for both, they put themselves in difficulties because it's well known that it's difficult for agents to owe conflicting duties to two people with different interests.
And I'd accept that it's difficult for agents to owe duties to principals where duties might conflict. But what matters here in our submission is what's actually happening. And again, one has to look at the proper interpretation of the directive. If somebody's doing something they shouldn't be doing, even if it's unlawful, not if you go so far as selling narcotic drugs unlawfully, because that would be outside the VAT system altogether. But unless you get to that extreme, you can be acting unlawfully, and within the VAT system, we don't need to approach anything like that here. But in my submission, the possibility that there might be a breach of fiduciary duty plays no role in the particular transactions and acts we're concerned with here. So that's no deterrent or reason not to find that the supply is within the insurance exemption.
Presumably, it's standard that the commissions paid by insurers to insurance agents are exempt because they're intermediary services.
Yes.
And it would seem odd if it makes any difference whether the insurance agent is acting for both parties or any one of them. I mean, not on the facts of this case, but a perfectly standard case where you pay commission on a policy, you don't pay VAT on it. Is that right?
That's right. And of course, why it matters here whether these services are taxable or exempt is if they're taxable, they do carry with them a right to deduct.
This is all about reclaiming the input tax.
Yes.
Yes.
And if they're exempt, they don't. And we're back to where everybody thought we were at the beginning. That there are exempt supplies of insurance carrying on here, and there isn't some carved out taxable supply for consideration of the device. There may be, if we got to this point in the argument, there is such a supply for consideration, but in our submission, it's still an exempt supply.
Can I ask you one other question, and then I'll shut up, which is, when Article 135(1)(a) says member states shall exempt the following transactions, is that mandatory? It's not. I mean, sometimes there's an option given to member states whether to exempt things or not, but is this a mandatory exemption?
It is a mandatory exemption. And without taking us off into territory that we don't need to go into, I think it's been widely acknowledged that it would not have been possible for Parliament to remove some of the education exemption whilst the United Kingdom was still a member of the European Union, and I think I don't want to expand it into that. But those are my, I hope, reasonably short but sufficient submissions on taking with my skeleton argument on why we say this is an exempt supply.
May I just add one further point? I mean, if this argument is right, it's a complete answer to the appeal, isn't that correct?
Yes.
I guess slightly wondering why this hasn't been at the forefront of the revenues case from day one, rather than just emerging at the very close of a 2-day appeal. If it's really as simple as you're now trying to persuade us it is.
Well, maybe we would, our approach reflects a certain loyalty to the Upper Tribunal and the First Tier Tribunal and its decision making. Perhaps one should remember the maxim of taking one's best point first, regardless of that. But we tried to defend the appellant's appeal, and then we've put in our answer. And if there's been, with hindsight, too much time spent on one point, and it's not just left me or my learned friend without time to finish this hearing today, we've been able to cover it now. But this is not, it'll be obvious, this isn't put in as a sort of make-way point or a point of desperation, and it was very much been to the fore and centre of HMRC's submissions in the First Tier Tribunal and the Upper Tribunal.
Thank you.
So those are my submissions.
Thank you very much. Ms. McCarthy.
Thank you. If I may start with the exemption point first, since it's fresh in everyone's minds. And how can I approach it? So the rationale of the Upper Tribunal's decision is simply because a supplier may be an insurance agent or an insurance broker in relation to some of its business. We have to look at the supply with which we are concerned, and what is the content of that supply. My learned friend has just suggested now, without any authority at all for his proposition, that once an insurance agent, always an insurance agent for all purposes. And that is startling, bearing in mind you would have thought that if that was the proposition he wished to make in face of the Upper Tribunal's decision, he would have come armed with some authority to actually prove it. We accept that as between Ingenie Services to the underwriters, they are of course exempt. That is because of the relationship Ingenie has with the underwriters under the underwriting, the Cavia agreement that we've seen. It's insurance, intermediation services, that is the status, that is what Ingenie is being paid for.
And do you agree with the submission that was made that the fitting of the device, as between ISL and the underwriters, is a supply to the underwriters because it's pursuant to a contractual obligation to do so?
So, we do not agree that the self-same device services being provided to the policyholders are also being provided to the underwriters. What we say the underwriters are receiving are insurance intermediation supplies, which include as their components certain obligations to provide the device services to the policyholders. And that was paragraph 101 of the Upper Tribunal's decision, essentially the way that the Upper Tribunal viewed it.
So just unpacking that for a moment. Providing and installing the device are part of the insurance intermediaries supplies which ISL makes to the insurer.
If we were to stand, if this was about analysing those transactions, you would stand back and say that is a single supply with a number of components in it, some arguably taxable components, others clearly exempt components. Overall, it's an overall exempt supply. That's how you would analyse that supply. And that's not simply saying it's one thing, that's looking at the single and multiple service single and multiple supply case law and looking at that as a whole.
But why does one have to look at it as multiple supply when the insurers and ISL have taken care to identify what part of the commission is attributable to the installation of the device, and in particular that a sum is payable if the device has to be fitted and not if it doesn't have to be fitted.
So, taking one step back, if we were looking at, which we haven't done at all in this hearing, the nature and the VAT classification of the supply from ISL to the underwriters, that would be a supply of a number of different individual elements. Some of them are taxable elements in relation to the device, others of them are exempt elements in relation to the in relation to the bringing together the parties, go out and find the policyholders, bring them together, and that's what you're being paid the commission for.
Which would be the taxable elements?
So, the elements that relate purely to the device. Pause, and I simply say elements, I'm not talking about supplies at this stage. Pausing there, it might be...
So why would they be taxable, not exempt? As between ISL and the insurers?
Well, because we'd have to look at Note 4 and see precisely where they fell into the Note 4 classifications. But pausing there, it might be the case that we had come to this court to say, well, actually, what's going on as between ISL and the underwriters is a multiple supply. We've got some taxable things and we've got some exempt things. The answer to that is no, it's not. When you apply the single composite supply analysis, which is set out in different cases that we haven't looked at, it's not been an issue between this court. The way to approach that would be to say, looking at all the elements in a whole, what predominates?
Well, I understand that, but the premise is you've got some exempts and some taxable
elements.
Elements. And I just don't understand what the taxable elements are by reference to what we're concerned with, namely the supply of the device.
We're not concerned with this supply at all. I'm simply trying to explain how I get to a position. Why is it that we get to the position that what ISL is supplying to the underwriters is a single exempt supply of insurance intermediation services? The analytical way of looking at it would be to look at what the elements of the supply are, then ask what predominates. And what predominates as between ISL and the underwriters is clearly the intermediation, the bringing together the parties, everything under that contract that we have looked at that goes far beyond the provision of the device. That would be the predominating element. If somebody was trying to say, oh no, these should be seen as multiple supplies, they might argue because of the way the consideration is split up. The cases tell us that simply because you've got separate consideration doesn't mean you've got multiple supplies. So holistically, analytically, notwithstanding that supply concerns a number of elements, as a whole it would be within the insurance exemption, and no one's ever tried to say anything else. Looked at in terms of the conditions, it's also plain that in relation to that supply, Ingenie is acting as an insurance agent, because that is its capacity, that is what it is being remunerated for. It is being remunerated by the insurers to go out into the market, find some customers, do everything necessary in order to conclude the contract of insurance, collect the premiums, and so on and so forth. Ingenie is undoubtedly in relation to that service an insurance agent or broker. There's no question about that. But that does not mean that because in relation to some supplies, insurance, ISL is an insurance intermediary, therefore in relation to everything it does, everything else it does, it must have the status of insurance agent, insurance intermediary. And that's what the Upper Tribunal set out clearly. My learned friend has not brought this court a single authority that says just because you're an insurance intermediary in relation to these supplies over here, regardless of anything else, you are therefore an insurance intermediary in relation to all the rest of your supplies.
No, but you're confusing me by what the insurance supplies over here are and the ones over there. He's saying, as I understand it, that if you look at the position as between ISL and the insurers,
yes,
if you treat this as an element that has to be taken into account in the multiple factorial, this is intermediary services this, not something else, as between ISL and insurers.
Yes.
And you accept that?
And as between ISL and the insurers, that's correct.
Right.
But we aren't concerned with that supply. We're concerned with the supply as between ISL and policyholders.
Well, it's the same thing.
Well,
It's the same.
Well-
It's the same physical performance, which is the supply of things to two different people.
well, hang on a second. It just in relation to the supply element, the supply that ISL provides to insurers is of all sorts of things, including, I accept, contractual promises that it will go ahead and fit devices in cars. And we can see that from the, we've seen that from the contract.
Yes.
Now, ISL is an insurance agent in relation to that. Those are intermediary services. No one's disputing that. Those are exempt intermediary services. Looked at as a whole, it's a single composite supply of insurance intermediation. Now, pausing there, that single supply of insurance intermediation with all aspects is not the same as that which ISL is doing for policyholders. The supply that we are concerned with, as between ISL and policyholders, has been demarcated by Part 1 of the policy booklet, and the Upper Tribunal has told us, and this is our starting point, it is a supply of device services, being the provision of the device to you, the policyholder, plus fitting in your car. And if we get to this point in the analysis, that is the beginning and the end of what the policyholders have paid for, those two things plus data services. The policyholders are not paying, in inverted commas, for example, for the service of being introduced to to an insurer. How can they possibly be when the very consideration of ISL supply to the policyholder is the conclusion of that contract? They aren't in any way paying for introducer services. Moreover, it would be incompatible, and this is why I spent such a long time on day one, going through the insurer's contract and showing exactly who ISL owes all of those obligations to. ISL collects money, it's collecting it as agent of the insurer. ISL owes all of its intermediary obligations to the insurer. Now, Marlene Friend has at no point pointed to any term in the contract that we are concerned with that shows that ISL is offering any other service in return for consideration to the policyholder other than those things that the Upper Tribunal has identified. What the Revenue's argument is properly understood. Our starting point is the Upper Tribunal has identified device fitting and provision of the device as services provided from ISL to the policyholder. What Marlene Friend's argument is seeking to do, in effect, is it's seeking to say, well, because of our other supplies that we are making, and because we are an insurance agent in relation to those other supplies, and stand back and look at all the circumstances and all the rest of it, somehow this infects the supply to the policyholders. But the supply to the policyholders has already been identified as device fitting, provision of the device, and it is not, for example, a supply of introducer services, because that's exactly what the ISL is providing to the insurer, and ISL is being remunerated by the insurer, and there's no suggestion of any other remuneration or any other service. We mentioned the TOBA. The TOBA is very clear. The TOBA, under the TOBA, ISL is seeking to introduce to the policyholder ARL, that's what the TOBA says, but it's also clear under the TOBA, ISL is not being paid anything for that introduction, which is another fact that the Upper Tribunal took into account. So what really Marlene Friend is trying to do is two things. relitigate the question about what are the ingredients in the supply under Part 1 of the policy booklet, but you can't do that. That's been decided by the Upper Tribunal. The ingredients are fixed. There's no respondent's notice trying to add other ingredients into that. He's then trying to say, well, because some of ISL's admitted business with other people, admitted supplies to other people being the insurers, is in an insurance agent capacity, ISL therefore must be an insurance agent for all purposes, including in relation to these narrower supplies. And that is analytically wrong, because when the Upper Tribunal made this is the finding that the Upper Tribunal made on the law. Note Article 135, Note 4. Item 4. In order to be providing services of an insurance intermediary, you need to be an insurance intermediary in relation to those particular supplies. So, in a world where we have already demarcated the entire supply, we know the supply in question is that which is made under Part 1 of the policy booklet. We are told it is a supply in relation to device fitting plus provision of the device. Those are the only two ingredients. ISL is not doing anything else for the policyholders for remuneration. Anything in relation to an introducer service to ARL under the TOBA is not part of the supply we're concerned with, beyond any view isn't being remunerated. That's the beginning and the end of this argument. That's why it's not front and centre of the revenues case, because by the time you get to this stage of the analysis, they're left trying without any authority at all to say, oh well, ISL is acting as an insurance broker or agent in relation to some supplies, the insurer supplies, the underwriter supplies. Therefore, that somehow infects everything it does.
This aspect of the underwriter supplies.
And that's simply not how the insurance exemption works in circumstances where the starting point is exemptions have to be strictly construed. The plain reading of the language is what the Upper Tribunal agreed with, and the Revenue has not brought any authority at all to show that actually, if you're an insurance agent in relation to some of your supplies, you're necessarily an insurance agent in relation to all of your supplies.
No, I think the argument is you are an insurance intermediary in relation to this aspect of the supplies, vis-a-vis the insurer, and you have to say, well, you can say, well, because the same supplies are being supplied to the policyholder, in that context, they're not being supplied as an insurance intermediary.
And that's
not a difference between the type of supply we're talking about. It's a difference between the people to whom the same supply is being provided.
Well, and I think it in relation to the non-monetary consideration point, it wasn't relevant whether it's the same supply or a slightly different supply. This, I think, it is relevant to be clear. The device services supplies are being provided by ISL to the policyholder. So far as ISL and the underwriter is concerned, it's providing a composite overarching supply of insurance intermediation. Part of that may well be the obligation to procure it is done, so some sort of fulfilment supply. That is not the same as the actual supply of the device services. I showed your lordship the Tesco food time case. There's a difference between Pizza Hut supplies a pizza to the customer, that's a supply of a pizza. Pizza Hut is not also supplying pizza to Tesco. Pizza Hut is supplying a fulfilment service to Tesco. So it's not exactly the same supply. Now, in relation to the broader question of Marlene and Friend's other submission became, well, somehow the mandatory nature of what ISL has to do under the insurance contract somehow diminishes the relevance of its supply to the policyholders. That's seeking essentially to relitigate the door that's already closed. We have already established that there is a supply of these two things, which both of them on their face are taxable things, to the policyholders. That is the content of the supply. And it's not for my learned friend to take us 2 steps back and argue about whether that's a supply at all, to whom it is made and what the content of the supply is. Now, if I can ask your lordship simply to look at the, if we look at the VAT legislation for the moment, which is in Authorities Bundle, page 94. And the revenue are relying on item number 4, the provision by an insurance broker or an insurance agent of any of the services of an insurance intermediary. And then this, in a case in which those services are related to an insurance transaction, then this, and are provided by that broker or agent in the course of his acting as an intermediary capacity. So, in order for my learned friend to get home, step 1, ISL has to be acting in an intermediary capacity in relation to the supplies it makes to policyholders. And we say, well, it's not acting in any intermediary capacity, because once you accept, and this is the starting point, that this is where we are, that those supplies are from ISL to the policyholder of device fitting and of device installation. That's not in an intermediary capacity. That's certainly not in an intermediary capacity as defined by Note 2. An insurance broker or insurance agent is acting in any intermediary capacity whenever he's acting as an intermediary or one of the intermediaries between a person who provides and a person who may be seeking insurance. ISL is not acting in relation, in that capacity, in relation to the supply with which we are concerned, which is the policy booklet part 1 supply. Not concerned with any other supply. And as I've already reiterated, the fact that ISL is acting in an intermediary capacity in relation to the supplies it makes to the insurers does not mean, and the revenue have not provided any authority for the proposition that therefore that term is automatically satisfied in relation to any other supply that entity, that ISL may make for any other purpose. Because the insurance intermediary capacity is on a per supply basis. It doesn't operate for all purposes. It can't start infecting other supplies, where on its own terms, in relation to the supply that we are concerned with, there's no intermediation, there's no intermediary capacity. And that was the point that the Upper Tribunal did make. So the Upper Tribunal made 2 points. Its decision is from paragraph 45 onwards on this. So Upper Tribunal 47, the point that the Upper Tribunal makes is, in effect, for ISL to be providing an item for supply, it must be provided in the course of his acting as an intermediary capacity in relation to that supply. That's absolutely right. And the revenue strikingly have shown you no authority at all to suggest that that statement is wrong. That's also the meaning of Article 1351A. The revenue have not sought to say, oh, well, actually, that part of Note 2 doesn't correctly transpose. What we know should be strictly construed exemptions, as my learned friend has accepted. And that was the Upper Tribunal's finding at Upper Tribunal 47. And then for item 4 purposes, the services of an insurance intermediary are defined by Note 1, and ISL is not providing to the policyholder any services of bringing him together with the insurer that the policyholder is paying for. And we know this can't be, because the CAVIA agreement that ISL has with its underwriter That's the only agreement under which exempt insurance intermediation services are being bought and paid for. And once it's accepted that ISL's duties in relation to its insurance agent, insurance broker type services are being provided to the insurer, there's no room for ISL to suddenly be remunerated for the same sorts of services from the policyholder, and we simply don't find that in Part 1 of the policy booklet.
Well, the remuneration, as you put it, is another way of describing the consideration which the policyholder provides for the performance of the services, which, when we've got here, is entering into the contract of insurance. So you say the policyholder isn't paying for these services in any way. The policyholder is paying for these services in the sense that it's the consideration which is being provided is entering into the policy of insurance. And that is what enables ISL to earn its commission as an insurance intermediary.
So if I may, the services we are talking about at this stage are simply device fitting provision of the device services.
Yes.
My learned friend has not pointed to anything under Part 1 which in fact he can say, oh well look here, in fact ISL has promised to do some sort of introducer service in relation to the policy. And the point about, because it doesn't exist, all Part 1 is dedicated towards are the services in relation to the device. That's it. My learned friend has not tried to shoehorn in there some other ingredient that would open the door to any of these other notes on the page. And he'd have to try and shoehorn that in, because we know that our starting point, as we keep acknowledging, is the supply found by the Upper Tribunal is of provision of a device and device fitting. There's nothing else that the fact that ISL might perform these functions while at the same time it is discharging its obligations under the insurance under the contract it has with Covea, and under that contract it's an insurance intermediary, does not make it an insurance intermediary into this contract. It's not acting in an intermediary capacity under Part 1 of the booklet. By the time we get to this stage, we are solely focused on Part 1 of the booklet, because that's the entire exercise. The entire exercise is Part 1 of the booklet. The Upper Tribunal and First Tier have acknowledged these device services are being provided. We have now succeeded in that they are being provided for consideration. That consideration is provided by the policyholder, and it is the policyholder's entry into the insurance contract. If the policyholder's entry into the insurance contract is the consideration he is providing to ISL, necessarily that can't be in return for some bringing together with the insurer service that ISL is provided to the policyholder, because the only bringing together service ISL performs is to the underwriter. And those are the findings of the Upper Tribunal at 47.
I don't follow that. I thought the whole premise of your ground 1 is that it's because and in return for your promise to install the device,
yes, that
the assured enters into the policy. That's the consideration.
Exactly. That's the consideration. But
And why is that not something that ISL is doing, which, in the words of Note 1A, is with a view to bringing together the parties?
Because ISL isn't doing it, because on our interpretation, it's the policyholder that is doing it. The policyholder is the one providing the consideration by entering into the contract. ISL is not being remunerated by the policyholder for being brought together with the insurer. The insurer is remunerating ISL.
That I understand, but
For bringing-
let's just look at the activity first, as opposed to where the remuneration comes from. The activity we're concerned with is the promise to supply, and then the supply of the services to the policyholder, which the policyholder pays for, or in consideration for which the policyholder enters into the contract of insurance. Just stop there for a moment. Don't worry about where the remuneration comes from. Why does that not fall within note 1A and or B?
Because we've already identified at this stage that the services are the services in relation to the device. So
Sorry, the services are...
the services under Part 1 of the policy booklet
Yes,
are in relation to the device.
yes.
In providing the device, fitting the device, collecting data from the device, giving an app to the policyholder, sending that data to the insurer.
Yes.
So none of those all of those actions are in relation to the device. None of those actions are bringing together the two parties.
Why not? Why not? If the promise is made specifically with a view to the quid pro quo, namely that there will be insurance entered into, which I have to say strikes me as the reality of the situation, quite apart from that being the consideration you contend for, why is that not bringing the parties together to create a contract of insurance?
Because first of all, the exemption has to be strictly construed, and the analysis here is because we promise to do certain things in relation to a device, as a result of which you're encouraged to enter into another contract, that therefore is the relevant bringing together. We say that's too remote in circumstances where our starting point as a matter of European law is that exemptions to be strictly construed. So what we cannot look at is anything that is beyond the service that we're immediately concerned with, which are the device services that I've just articulated, to say, oh, well, somewhere further down the line, we see there's an insurance contract coming into being, that this has had some role to play, because that would be giving an expansive interpretation.
By something further down the line, you include within that something which is the quid pro quo for the services.
And I think the point that I'm trying to make is...
But that is the effect of your argument, isn't it?
But
that you ignore the quid pro quo and treat the entering into the contract as something which is further down the line and for these purposes unconnected.
But if I may say, what we need to establish here is what is it that the policyholder is paying ISL for? But if part of that remuneration, so to speak, is the entry into the contract, in circumstances where ISL cannot act as an insurance agent for the policyholder, because ISL is already acting in that capacity for the insurer. So there are two separate questions here. There's a question about the activities. In relation to 1A, we're confined by the terms of the policy booklet, and I say that anything beyond those terms that may be consequential is too remote for a strict exemption to apply. The other issue which the Upper Tribunal identified is there's also a capacity issue. In what capacity is ISL acting in relation to the supply with which we are concerned? And the capacity is not as an insurance agent or insurance broker. At this stage, in relation to Section 1, it's a technology provider. It's a principal to customer relationship. It's not acting as an insurance intermediary. So there are two aspects. One is, what are the elements of the supply? And we can see clearly from the face of the policy booklet exactly what those elements are. Two is, in what capacity is ISL making that and only that supply? And ISL is not acting as an insurance agent in relation to that supply, and ISL isn't being remunerated under, for example, the TOBA for introducing the policyholder holder to ARL. And the starting point with all of this, as against which there's no respondent's notice, is we have established the contents of the supply that ISL is making to the policyholder as being the 4 or 5 device-related ingredients and data services. Forget data services because that's not part of this appeal, but they're the elements that are on the face of the insurance contract. Can I also make another point? This is the point about, but surely the entry into the contract can somehow be consideration for something else for bringing together. In circumstances where we've established, I think, that Part 1 of the policyholder booklet is a unilateral contract, there's no prior agreement with anyone that ISL will bring you together with an insurer. That isn't a service that ISL is offering to the policyholder. That is a service that ISL is offering and is paid for to the insurer.
No, but that's also, insofar as it reflects the contents of Part 1, it's what ISL intends to get in returns for its promise.
But the promise ISL makes in Part 1 is confined purely to the device and the provision of the device. It's not acting as an insurance agent, it's acting as a technology provider. That is its status in relation to Part 1. And it's not possible to say, well, because of some overarching entire context in which ISL does other things for other entities, the status that ISL has in relation to those other suppliers vis-a-vis the insurers can somehow be transposed and imbued on ISL in relation to the policy.
One's got 2 questions. Is this right? One's got 2 questions under the Act.
Yes.
First of all, for our purposes, whether under Note 1, the services which ISL are providing are services of an insurance intermediary, and that one has to come within A, B, C of those.
Yes.
And then there's a separate and second question as to whether those services are provided in an intermediary capacity,
Yes.
so as to fulfil Note 2. Now, taking those in stages, if at stage 1, what ISL intends to get and does get in return for its promise is a contract of insurance entered into by the policyholder, then the question arises as to whether that is part of bringing together those who are seeking insurance and prepared to give it, or carrying out work preparatory to the conclusion of the insurance.
And we say it can't be that because the bringing together will have already happened, but it's not a walk to York and I'll pay you £100 scenario. The walk to York and I'll pay you £100 is if you enter into these insurance contracts, here are my promises to you. By the time the policyholder has entered into the insurance contract, necessarily he's already been brought together, but there's no prior bringing together promise that is then franked to create some sort of prior stage bringing together supply.
Well, that's what the contract. If it's a contract at all, as you say it is, it's because you make that promise in advance, with a view to encouraging the quid pro quo, which is the policy being entered into.
But necessarily, the bringing together has concluded by the time the policy has been entered into.
Yes, but not by the time the promise is made.
But the walk to York, I'll pay you £100 is if you enter into the insurance contract, ISL will do the following things for you.
Yes, that's what, that's what Part 1 is.
And if they enter into the insurance contract, necessarily the bringing together is over. So if you enter into the insurance contract, ISL will bring you together with an insurer, but that's happened because the bringing together is concluded by the conclusion of the insurance contract.
Well, if you're right about that, then I don't see how you can say the consideration under ground 1 is entering into the contract of insurance.
But sorry. The bringing together is all the work that is done prior to the contract of insurance being concluded. The device services that we are providing are everything that ISL will do after and because of the contract of insurance has been concluded.
Right.
So it isn't the same as the argument we are making in relation to the device services, because the unilateral contract in that case, if you enter into the insurance contract, then we will provide the various device services. What is being anticipated here is a bringing together, an introduction that is something that necessarily has to happen prior to the contract being entered into. ISL owes the policyholder no obligation whatsoever to find an insurer for it. Whereas ISL owes the insurer obligations to find some customers and to advertise and market and blah, blah, blah. ISL at no stage is under any obligation to a policyholder to find it insurance. That's simply not the deal that ISL has done with the policyholder. So walk to York, there's no obligation on anyone to walk to York. There's no obligation on anyone, on ISL, to find that insurer, that policyholder and insurer. Once, however, the policyholder has decided that he wants to enter into this insurance contract, the entry into the insurance contract then is that which imposes on ISL the obligation to go and fit the box and the power and so on. But part one of the policy booklet, which is the only thing we're concerned about at this point, by the time we got to this stage of the analysis, that's the totality of the supply, that's fixed, it's for consideration. There is nothing in that part one that can be interpreted as an obligation on ISL to go and find the policyholder insurance. And necessarily commercially, that exercise has already been done. Because part one of the part one of the booklet comes into being because of the consideration the policyholder gives by entering into the contract. ISL has made no promise to it to do anything in advance, commercially, contractually, whichever way you look at it. And then there's the separate question of what then, in relation to the supply of services for consideration that we've identified and we've ring-fenced, because that's fixed by the time we get to this stage of the analysis, what capacity in relation to that supply, and only that supply, is ISL acting in? And it's not acting in an insurance intermediation, in an intermediary capacity in relation to those services and those supplies.
And do the two have to stand or fall together? Suppose that you were wrong in relation to whether these were insurance intermediary services of an insurance intermediary. For the purposes of Note 1,
Yes.
you still say it's possible that it was not acting in intermediary capacity in providing what are intermediary services under Note 1.
That's the function of how item 4 reads. So it's unfortunate it's cut over 2 pages in our bundle, but item 4, which is your starting point, sets out the test, and both Note 1 and Note 2 have to be satisfied because that's the test. The test is A and B.
Well, B is part of the provision of services of an insurance intermediary.
And that is defined by 2. What is meant by acting as in an intermediary capacity? So that has a specific statutory definition, which is Note 2. So in answer to your Lordship's question, yes, you need Note 1 and Note 2. And without one or the other, you don't get that. And I would reiterate.
But on the facts of this case, you still say if ISL was in fact under Note 1 providing insurance intermediary services, it wasn't doing so in an intermediary capacity.
in relation to the only supply that we are concerned with, which is the policy, the Part 1 policy booklet supplied to policyholders that ISL makes, exactly. Yes.
Thank you.
So that's, sorry, before I want to leave this, the important point I would make on that second point is my learned friend has not shown this court any authority at all for the proposition that because ISL may be acting in a certain capacity in relation to supplies to insurers, that capacity somehow carries over in relation to supplies made to policyholders under Part 1 of the booklet. Precisely because VAT is a tax on transactions and the concept of supply is a self-contained holistic supply, and you have to look at whether the terms are met in relation to that supply and that supply alone, not some other supply. And the Upper Tribunal had no problem, nor did the First Tier, but the Upper Tribunal in particular had no problem with that, which is, certainly as a matter of VAT, a fundamental concept. And the Upper Tribunal dispatches of it very quickly in its decision. If I can just make, so that's all I wanted to say in relation to the insurance exemption, and why it is that the revenue is simply trying to make the exemption do too much and to borrow from other supplies in order to get it over the line in relation to this supply. If I can just briefly pick up on a couple of other points, please.
Sorry, can I just ask you one other thing?
Yes, of course.
For the purposes of note 2, someone acting in an intermediary capacity, can someone be acting in an intermediary capacity if they're not acting as agent of the insurer or the assured, but they are simply an independent intermediary? So they don't have an agency capacity for either of them. They're just bringing them together as an independent person.
Forgive me, my lord, but for that, I think they'd have to be acting in an agent capacity for one of them, because otherwise the question is only relevant if you've established a supply for consideration. So I think that in your example, in order for this question to be relevant for VAT, one or other of the parties, somebody would have to be paying that agent, that person under a legal relationship, and no doubt therefore that would mean that they were an agent of that person.
Well, I'm not sure I follow that. One can have an entirely independent intermediary. They may be paid by either or both parties without having any authority to act on either of their behalf. One has that kind of independent intermediary in many aspects of commercial life.
Okay, I'm not sure of the. Well, I think in that circumstance, I don't think he'd qualify as an agent or broker. If he was acting purely independently and not as an agent of either, I'm not sure in that capacity he would fulfil the requirement. This is a provision by an insurance broker or an insurance agent. So I'm afraid I'm not sure I quite. I don't think I've quite grasped your lordship's question.
No, well, I
think that would be problematic for other.
I understand. I say that we may be going off into an area that requires rather greater consideration, but maybe one can have insurance agents who are not people who have authority to act on behalf of either the assured or the insurer, but are agents in the sense of intermediaries. I can certainly have that in other aspects of life.
Okay. I'm not sure of the broader answer to that deeper question. No. But equally, whatever the answer to that question is, that's not the capacity in which ISL is acting vis-à-vis the policyholder under Section 1 of the policy booklet. And we have.
I thought you said it was. I thought you said it wasn't acting as in its capacity as an insurance intermediary, because it was acting independently on its own behalf.
Sorry, I think my "not" must have been in the wrong. ISL is not acting in an intermediary capacity when it is making tech supplies. It is acting for its own purposes as a tech provider. That is what Part 1 of the policyholder booklet, which we are concerned about now, it is all about. That is the supply that's been demarcated by Part 1.
It's not just acting independently, but it's acting in its capacity as a tech provider.
But vis-a-vis those services, yes, because all of those services are in relation to the device and data. I mean, that's loose language, but that's essentially what its function is in relation to those supplies.
Thank you. Forgive me, you were going to move on to...
Sorry, I'm also conscious of the time.
Yes.
Can I please just address you then briefly on non-monetary consideration? I think in the interest of time, I have nothing more to say on monetary consideration, so we'll just deal with non-monetary consideration. If I can ask you briefly just to take up paragraph 47 of our skeleton argument, so that's core bundle, tab 4, page 44. I want to be very clear, because my learned friend pointed to that, to say, oh well, lim A of that is simply just two things that happen sequentially, and reciprocal performance is more than two things happening sequentially. I hope it was clear that by the time we got to the end of our submissions yesterday, our case on non-monetary consideration was much more than two things happening sequentially. If I can simply, paragraph 47, its role originally was intended to say, this is what our situation is, I didn't think it was disputed, and that is good enough. It was not trying to say, in order to win, we must establish these two things. That wasn't the role of 47. We say we don't need to establish 47B, and what I would say is by the time we reached the end of the submissions yesterday, the end result is I would modify 47A slightly, so that what we are saying is that as a matter of both contractual obligations and reality, the agreement between ISL and the policyholder was, if and only if the policyholder entered into the insurance contract, ISL was obliged to supply and did supply. So that's the adjustment I would make. ISL was obliged to supply and did supply the provision and fitting of the device in return. And that, I think, quite clearly was the thrust of my submissions by the time we concluded yesterday. And we say we have that contractually, and we say that that is sufficient for direct link and the cricket about me. Moving on then, if I can just deal with my learned friend submissions in this way, the thrust of his main objection on direct link boiled down to there couldn't be a supply for consideration between ISL and the policyholder because ISL was already committed to providing services, including in relation to the device, to the underwriter. That became the thrust of the submission. But properly understood, analytically, that is a submission that is really aimed at whether or not ISL was making a supply to the policyholder at all. And we've done that. That's been done. If I can take your lordships just to two passages that we've seen before, but these are important in South African Tourist Board. So that's back in the authorities bundle. We can see that the Upper Tribunal in South African Tourist Board, so that's authorities bundle, tab 20, paragraph 49, specifically rejected a point of principle taken by the revenue that just because the South African Tourist Board was required by statute to do certain things, it therefore couldn't be making supplies for consideration. And the finding by the Upper Tribunal was it can be making supplies for consideration, it's discharging its statutory obligations by making supplies for consideration. And we say that analytically exactly the same happens here. If ISL owes obligations to the insurer, it is discharging those obligations by making supplies to the We also know that yes, the starting point, and my learned friend took your lordships to secret hotels too. Who supplies what to whom is a multifactorial assessment looking at all the relationships. But again, with respect, we've already answered the who supplies what to whom question. The Upper Tribunal has told us that there are supplies of the device-related elements from ISL to the policyholder. And again, we know from South African Tourist Board, once you've nailed down the existence of a supply, because this is what the Upper Tribunal said in relation to the Netherlands Tourist Board case, it's not surprising that it follows quite easily from that, that there is the finding that something was given in return for that supply. And my Lord Justice Popplewell, I think, was right to say, once it's established that there is a supply from ISL to the policyholder, pursuant to the legal relationship created by Section 1, it is a completely independent question as to whether there is non-monetary consideration. And that independent question cannot be affected by whether something else is being obtained for some other supply under some other contract. So the Court of Appeal's questions to my learned friend, we say are entirely the right questions to ask, and the answers are, it is an independent exercise. My learned friend also at some point seemed to suggest that you can't provide the same supply to two different people, and that somehow was the problem that was happening here. But that's simply not right for two reasons. One, as I've already explained, it's not the same supply that is being provided to the policyholder and to the insurance underwriter. The policyholder is getting the supplies in relation to the device. The underwriter is getting some sort of fulfilment service that is wrapped up in the overall intermediation service. Test that out with Pizza Hut providing pizza whilst at the same time providing a fulfilment service to Tesco as a result of Club Card wins. But the second point is, it doesn't matter for that the same costs incurred by ISL are used to provide two different supplies. And I think, my lord, you said at some point, I paraphrase, but the gist was presumably there's a function of VAT accounting, which is exactly right. As a matter of VAT, it is perfectly possible for one supplier to use some of his costs for taxable supplies, the same costs for exempt supplies. That's exactly why you have attribution, partial exemption methods, and all that computational aspect that isn't before the court. It is precisely because costs incurred by a supplier are then used for two different types of supply. And all the partial exemption cases tend to arise because some of the uses for taxable supplies are other usages for exempt supplies. So there's nothing objectionable. Once you understand that actually the substance of most of my learned friends' arguments were really trying to refight, well, ISL isn't actually making a valid supply at all to policyholders because look what it's doing for the insurers. That battle is dead. My learned friend has said quite rightly he's not seeking to reopen it. Direct link is a simple question that is answered by the cases. And in a case such as this, by the time you've identified that there is a unilateral contract, of course you won't see unilateral contract anywhere in VAT cases, but you've identified that there is something being done in return, and that in return is sufficient, ample to be a consideration for VAT purposes. If I can just have one moment to make sure there was nothing else on that point. Really, we say where my learned friend goes wrong is he goes wrong in his contractual analysis. So my learned friend's position was that he didn't accept there was a unilateral contract. If you disagree with him on that, then necessarily that is because you've accepted our submissions as to the respective rights and obligations, and you've rejected his submissions about the rights and obligations. In relation to then the VAT overlay, we have to start from not HMRC's misconceived view as to what the rights and obligations should be, but what we've just identified as them being, and the quality of the in-returnedness, if I can say that. My learned friend also at no point has tried to say Thorne is wrong, and if Thorne is right, then again, this is exactly the sort of case that we are. Things were said to be free and all the rest of it, same with Empire Stores. And so all his points about, well, there can't be a direct link because ISL isn't giving anything more or separate, or there's no room for this to be consideration, actually properly understood analytically, all of those are submissions that go towards there's no room for a further supply, but that ship is out. The last point then that I wanted to pick up on is the consideration capable of having a monetary value. We know the consideration is capable of having a monetary value because Empire Stores tells us what that monetary value is. And just a reference, the relevant paragraphs are 16 to 18. At one point, my learned friend started to say that there couldn't be consideration capable of having a monetary value because there was no detriment to the policyholder, but that isn't a test to be found anywhere in the VAT cases. And if I can just read the clear language at paragraph 18, just for your lordship's note in Empire Stores, 18 and 19, the CJEU says this, in unequivocal terms, as a statement of principle, where the value is not a sum of money agreed between the parties, it must, in order to be subjective, be the value which the recipient of the services constituting the consideration attributes to the services which he is seeking to obtain, and must correspond to the amount he's prepared to spend for that purpose. The only thing we need to establish is, as between ISL and the policyholder, there is no sum of money agreed between ISL and the policyholder for anything under Part 1 of the policy booklet. Quite apart from anything else, if there was a sum of money agreed, we would be here.
Yeah, a sum of money agreed must also encompass something of value whose value is agreed, mustn't it, between the parties?
And the point is, there is, in the language of Empire Stores, this is a case where the value is not a sum of money agreed between the parties. So there is no sum of money that has been agreed.
No, but I'm just suggesting to you that the Empire Stores position is you either have agreement, subjective agreement, or in default you apply the cost of.
Yes.
And although it is expressed as an agreed sum of money, one would have thought that the principle ought to be that if one can establish that subjectively they have agreed on what the value is by reference to something which isn't itself described as a sum of money, but can be ascribed monetary value, that would also come within the first category, and you wouldn't go on to the default position. That's all I'm suggesting to you.
That would be a case like Thorne.
Yeah.
So in default of that, in default of any absence of agreement, we are Empire Stores, and there's no problem in following through that analysis in order to get to cost.
Yeah.
If I may just make sure that there is nothing else I need to add in reply. Unless you have any further questions. Oh, I'm sorry. Unless you have any further questions, then those are our conclusions.
Yeah, thank you very much indeed. Well, thank you very much. We shall reserve our judgments. Drafts will be circulated in due course for the usual purposes, typographical and any minor factual corrections, not of course an opportunity to re-argue the case. We will hand down remotely. Before that, we'd invite you to agree the terms of an order, and if you can't agree, then put your rival submissions in writing to us, and we will resolve them on paper. Circulation to the parties or to any other person for the purposes identified in the Counsel General for Wales case is the responsibility of the solicitors, as they will, I hope, be well aware, and circulation may be only for those purposes, and any other publication may be a contempt of court. It just remains me to thank you. I don't just mean those with the speaking part. I know a lot of work goes into this by everybody for what has been a very interesting case. Thank you.
Court rise, please.